We'll go ahead and start the oral argument in the case of Rodriguez versus Epoch Management. I'm Judge Evander. I'll be presiding over the oral arguments today. Joining me on the panel are Judges Nardella and Wozniak. These arguments are being live streamed and also recorded. Each have 20 minutes aside for oral argument. The appellant is entitled to divide its time between a opening argument and rebuttal argument. Mr. Howard, how much time do you wish to reserve for rebuttal?
Your Honor, with this court's leave, could I please reserve 5 minutes for my rebuttal?
Okay, I'll try to help you in that regard, but you do have the clock there. And with that, Mr. Howard, you may proceed.
Thank you, Your Honor. And good morning. May it please the court. My name is Bailey Howard, and I represent the appellant, Cecilia Maria Rodriguez. And Your Honors, this court should reverse in this case because Epoch did not carry its summary judgment burden as to any issue presented here. The trial court overlooked the fact that Epoch did not provide any competent evidence under Florida statutes to support its affirmative defense of workers' compensation immunity. The trial court then applied a critical statute in a way that's contrary to the plain language of that statute, and then failed to apply the summary judgment standard correctly, interpreting the facts in the record in the light most favorable to the moving party, Epoch, and overlooking genuine disputes of material fact. And to the first point, Your Honors, Epoch was not entitled to summary judgment on its affirmative defense of workers' compensation immunity. And the threshold question here is whether Epoch even presented any evidence to show a prima facie entitlement to such to summary judgment on its workers' compensation immunity affirmative defense. And until the movement makes that prima facie case under Florida law, the non-movement has no obligation to come forward to present evidence and show that there are issues still to be tried. And the court's function is not to determine whether the non-moving party can prove its case at trial, but rather whether the defendant has absolutely shown that the plaintiff cannot prove its case at trial. And here, Your Honors, under section 440.09, subsection 1 of the Florida statutes, Epoch did not present any competent substantial evidence because that statute requires that a determination of workers' compensation compensability be proven to a reasonable degree of medical certainty based on objective, relevant medical findings. And Your Honors, the summary judgment record here is devoid of any objective, relevant medical findings, and it certainly doesn't suffice to prove something to a reasonable degree of medical certainty. We have deposition testimony, we have affidavits, and we have filings from a workers' compensation proceeding. And these
let me ask you this. Is there any dispute that the summary judgment evidence reflected that this incident occurred at the workplace and that your client was alleging that one of the supervisors for the appellee engaged in a wrongful act which caused your client damages at the workplace?
No, Your Honor, there's no dispute about that at all.
Okay, so where you're saying the burden fell was on whether there was a mental or nervous injury or lack thereof, that's where the evidence is lacking?
Your Honor, the evidence is lacking that the injury was compensable in workers' compensation at all, just on this record. Now, Ms. Rodriguez doesn't contend that it wasn't compensable. Mrs. Rodriguez, her original position in this case was actually that it was compensable in workers' compensation. And Epoch's position was that it was not compensable in workers' compensation. Ms. Rodriguez originally filed this as a workers' compensation case.
But there was no estoppel claim raised by Ms. Rodriguez in this case or anything relating to that previous case, correct?
No, Your Honor, there was not, although that's without prejudice to raise it at a later appropriate time if that became appropriate. But in this case, Ms. Rodriguez is certainly not contending that it's not compensable in workers' compensation in that original form, but Epoch hasn't proven that it's entitled to its defense of workers' compensation immunity. And under the exemption in section 440.093 subsection 1 of the Florida statutes, Ms. Rodriguez's original position that it was compensable, it turns out to actually be incorrect, because Ms. Rodriguez is trying to claim for physical injuries that are the result of mental or nervous injuries that are not accompanied by any physical trauma requiring medical treatment.
Yeah. Would you agree there was no medical evidence presented on the issue of whether there was a mental or nervous injury?
That's correct, Your Honor.
On either side.
Your Honor, yes, there was no such evidence, and the burden to present that evidence was Epic's moving on this motion for summary judgment, because they
But
had the
Ms.
burden.
Rodriguez did not file a reply or an avoidance to this affirmative defense, correct? And so doesn't that shift the burden to Ms. Rodriguez at the motion for summary judgment stage to prove the exception?
Not on the physical trauma exception, Your Honor, and arguably not on the intentional tort exception either, because under both of those exceptions, the Epic didn't raise Ms. Rodriguez's failure to file the avoidance in the trial court. So they waived that issue, and the parties tried the issue by consent. At this point, the trial court would still have discretion to allow Epic to file an avoidance out of time and cure that procedural defect. But at this point, Your Honor, the parties have addressed the issue on the merits. It is properly before the court, notwithstanding the absence of the avoidance. And this is—
Let me ask you about the waiver. Did both parties dispute who had the burden of proof at the summary judgment hearing below?
Yes, Your Honor, they did.
I mean, the appellee took the position that you had the burden of proof on proving that exception under subsection 1 of 440.093, and your argument was that they had the burden.
Yes, Your Honor, and Epic's argument, the appellee's argument, was incorrect. They had the burden to prove that this exception to the statute did not apply in these circumstances. And the court—
Given the lack of evidence and dispute over burden, it seems, would you agree with me, that who had the burden of proof might be critical to this appeal, at least on the first issue you've raised on appeal?
Yes, Your Honor, it's definitely very important.
What's your best case that the burden was on them?
The best case is that immunity is an affirmative defense that Epic had the burden to prove. They moved for summary judgment on their affirmative defense. And so if they can't clear the threshold of saying this injury was compensable, we don't even get to the exceptions, Your Honor. And that's where section 440.09 subsection 1 comes in, because Epic didn't present any competent evidence to support a determination that the injury was compensable. They simply did not carry their summary judgment burden. And that's not to say that Epic might not ultimately be able to come and prove at trial that it's compensable, and that Ms. Rodriguez wouldn't then be able to carry her corresponding burden to say that there is an exception to it, because at trial, Ms. Rodriguez would bear that burden. But on summary judgment, the burden is Epic's to show conclusively that it is entitled to judgment as a matter of law, and that there is no genuine dispute of material fact presenting that. Here, Epic failed to carry its initial burden to show the injury was compensable in the first place, and then Epic had the separate burden assigned under Florida's case law to show that the affirmative defense also was not applicable because of the exceptions in the statute that Epic, or rather that Ms. Rodriguez, could not satisfy that exception. This case is a little unusual in the workers' compensation context because, of course, the employer is the one trying to prove compensability. But the fact remains that they had the burden to show that the exception to the affirmative defense, the exception to the statute, did not apply to forestall their affirmative defense. And that's based on a 4th District case, Nowicki versus Cessna Aircraft Corporation. The movement on summary judgment, when it's a defendant moving for summary judgment on their affirmative defense, has a burden to show that exceptions to the statute do not apply.
Well, in Nowicki, was there a reply, an avoidance filed by the plaintiff to the affirmative defense?
Yes, Your Honor, there was.
Okay, and does Nowicki talk about how that's a significant factor in deciding the burden of proof?
Your Honor, Nowicki does analyze that with respect to a prior Supreme Court case that it's relying on, which the name of that case starts with an L, and I'm afraid it's escaping me.
Landers?
Yes, Your Honor, that's the case precisely. But Nowicki does not address whether a trial court would have discretion to file an avoidance out of time. What Nowicki says is there was an avoidance here. We don't need to address that. This case is stronger than Landers. But in this case, the trial court retains its discretion to accept an avoidance filed out of time. And furthermore, Your Honors, especially with regard to the physical trauma exception of 440.093 subsection 1, not only did the parties try that issue by consent, but Epic raised that one. Ms. Rodriguez raised the intentional tort exception, but it was Epic that brought the physical trauma exception into play in this case. And so Epic can't argue reasonably that it suffered any prejudice from being forced to argue an issue that it itself raised. And Your Honors, under section 440.093, the best, 440.093 subsection 1, which I'm going to continue to use the shorthand physical trauma exception for, the best reading of that statute is that Ms. Rodriguez's injuries are not compensable. Epic was right when in the workers' compensation proceeding, it said they were not compensable because of that exception. Ms. Rodriguez is attempting to recover here for physical injuries that she suffered as a result of mental or nervous injuries that were unaccompanied by any physical trauma requiring medical treatment. And the trial court—
This case different from Speed. Speed seems to control here, and I know that there's McKenzie too, and the parties discussed in their briefs which case applies more, but McKenzie's discussion of the third sentence of the subsection 1 seems to be dicta. And so, Speed had a heart attack. Here we have a stroke, or what the parties were calling a stroke. How does it differentiate?
Your Honor, with the proviso that Ms. Rodriguez doesn't believe that it's dicta in McKenzie, but Speed also does not control. This court is free to disagree with Speed. But the reason that Speed is not the best interpretation of this statute is that it seems to sort of eat the statute alive almost and turn it from an exclusion into an inclusion. If you look at Speed's reading of the statute and you diagram it out on the sentence almost, the mental injury part falls away. What Speed held was that a physical injury that is accompanied by or caused by a mental or nervous injury is compensable when it's accompanied by physical trauma that is also the physical injury you're trying to recover for. So a physical injury is compensable because it's a physical injury, is what Speed basically holds. And that is not a reasonable, or certainly not the most reasonable, with great respect to the First District Court of Appeal in Speed, it's not the most reasonable reading of this statute because it turns an exclusionary provision that you can only recover for certain injuries into an inclusionary provision where you can recover for basically any injury as long as it has this mental or nervous link. What section 440.093 does functionally is it distinguishes between, say, somebody who's hit by a truck and at work or hit by a forklift and experiences a mental or nervous injury and then a subsequent internal failure, as the court in McKenzie described, and it allows that person to recover. But the person who has a near miss with a forklift and just becomes very nervous is not able to recover. Whereas under Speed, that person would still be able to recover. There's a material difference between the statutes. And if you lay just the plain language of the statute on top of the facts of the case and read each word according to its most natural meaning, giving effect to each term in the statute, then Speed clearly, I would posit, is not the most reasonable way to read the statute.
Well,
and
let me ask you this. If you have an employee who suffers stress, fright, or excitement, no physical trauma, no mental injury, but then they have a subsequent physical injury, such as a stroke or heart attack, is your position that it's compensable or not?
That would not, I'm sorry, Your Honor, I didn't mean to speak over you. That would not be compensable, Your Honor. I'm sorry to do it a second time.
Okay. So if there's, all right.
And
what do you think a mental or nervous injury means in that statute?
Mental or nervous injury is not entirely clear in that statute, Your Honor. I would say that it's certainly ambiguous. The statute doesn't define it, but I would say a nervous injury would be an injury, to the nervous system or an injury of the nervous system. A mental injury clearly would relate to some degree to mental health. Not being an expert myself in those matters, I couldn't say what is and is not the limit of a mental or nervous injury, but certainly stress and anxiety is something that the First District has considered to be a mental or nervous injury in McKenzie, and those would certainly fall into that spectrum.
Well, let me ask you, you said we're not bound by the first, and I agree with that, but and I know there was a statement in McKenzie which kind of equates mental or nervous injury to stress or fright or excitement, but that would seem to make no sense in the reading of the first sentence in subsection 1, because then it would mean stress, fright, or excitement due to stress, fright, or excitement. It seems like mental or nervous injury would be something more than stress, fright, or excitement. Would you agree with that?
That's a
Well,
reasonable interpretation of the statute, Your Honor. Yes. It seems like reading the statute as a whole, it would have to be a particularly severe stress, fright, or excitement. You couldn't say I was nervous about whether I would be fired, so I stubbed my toe, or something like that. I was distracted by the heavy duties of my job might not be sufficient, but severe stress, severe fright. I was almost run over by a forklift, or I was hit by a forklift, or something along those lines. A severe stress, fright, or excitement, the statute still permits that, because the first sentence doesn't, if it does regulate as to degree, that's still a reasonable reading of the statute, Your Honor.
In determining what a mental or nervous injury is, in subsection 1, does the Diagnostic and Statistics Manual play a role?
Your Honor, I suspect that it would. That's a resource that professionals diagnosing those things rely upon. However, EPIC didn't present any such evidence in this case to support its determination that A, the injury was compensable, or B, that this exception didn't apply. And Your Honors, I see that I'm about
5 minutes. Okay.
Yes, Your Honor. And so I'll rely on my briefs for the remainder unless this court has any further questions. Otherwise, I'll save it for rebuttal.
Thank you.
Thank you, Your Honor.
All right, response.
Thank you, Your Honor. May it please the court, I represent the appellees, EPIC Management, Inc. and EPIC Properties, Inc. The framework of how the issues in this case regarding workers' compensation immunity are to be analyzed rests upon the proper allocation of burden of proof, as this court pointed out. On this critical point, Ms. Rodriguez was mistaken. It was EPIC's burden to show that workers' compensation immunity applies, not that her injury is compensable. The burden then shifted to Ms. Rodriguez to show that there were no disputed issues of fact, that the two exceptions, 440-093-1 and 440-11-1B1 apply. The court in Nowicki explained that where the plaintiff has not raised an exception to the affirmative defense as an avoidance or defense prior to summary judgment, the moving party does not have to conclusively show the non-existence of these exceptions to establish the right to summary judgment. Here, EPIC raised workers' compensation immunity as an affirmative defense, but plaintiff raised no exception, neither 440-093 or 440-11, as an avoidance or defense prior to summary judgment. Therefore, EPIC did not bear the burden of proving the non-existence of either of those exceptions, although it did meet that burden.
Let me ask you this. Obviously, we're not bound by Nowicki. What are the policy arguments to place the burden in this case on the appellant rather than the appellee, as far as proof of whether an exception applies or not?
It would make sense in this case, Your Honor, because again, EPIC needed only to prove that workers' compensation immunity applied. And then it's just as if it was an affirmative defense. It's an avoidance to that, these two exceptions. And so it's not requiring Ms. Rodriguez to prove her exceptions. It's merely requiring her to prove that, it's merely requiring her to show an issue, a genuine issue of fact exists. That's it. And she did not do it. And Your Honor, Ms. Rodriguez was also mistaken when she argues that EPIC was required to prove her injuries were compensable under workers' compensation. EPIC has always denied causation exists. And I note the case of McNair versus Dorsey, 291 Southern 2nd 607, in which the employee filed a workers' compensation claim. The employer denied that a compensable accident that caused an injury even occurred, and it also denied that it was within the course and scope of employment. The employee dismissed his workers' compensation claim and filed a civil lawsuit. The employer again denied that an accident that caused an injury had occurred. It won a summary judgment at trial that the workers' comp exclusivity applied because the accident, if it occurred within the course and scope of employment. The first DCA affirmed the summary judgment, holding, quote, a party should not be foreclosed from claiming entitlement to workers' compensation immunity simply because it denied compensability. And Your Honor, EPIC submitted uncontradicted evidence that shows workers' comp exclusivity applies. Epic submitted deposition testimony where Ms. Rodriguez testified she suffered a back and head injury as a result of a disciplinary meeting disciplinary meeting that was conducted by her boss's boss at work. This testimony, if accepted as true, falls squarely within the workers' compensation arena, and it was arising out of work performed in the course and scope of employment. That is all the evidence that Epic needed to submit. It did not have to prove causation. With respect to the exception of 440-0931, Ms. Rodriguez there was no evidence at all that 440-0931 applies. 440-0993 is entitled and addresses mental and nervous injuries. The court in McKinsey explained that mental and nervous injuries are certain psychiatric injuries. And in fact, the statute requires that they be diagnosed by a psychiatrist. As the court in Speed noted, quote, significantly, the first sentence of 440-0931 differentiates between mental or nervous injuries caused by stress, fright, or excitement, and physical injuries caused by mental or nervous injuries, close quote. For 440-0993 to even apply, there must be evidence of a mental or nervous injury, and there was none here. In fact, Ms. Rodriguez never even alleged she had a mental or nervous, i.e. a psychiatric injury. In Speed, which is like our case, there was no evidence of a mental or nervous injury, only stress. The court in Speed held that the claimant's heart attack, which was caused by a stress response to the elevator drop, was a compensable injury under 440-09 subsection 1, the general coverage statute. 440-0993 did not apply because there was no evidence of a mental or nervous, i.e. a psychiatric injury. In contrast, the employee in McKinsey sought compensation for psychiatric injuries, including PTSD and anxiety disorder, and she submitted medical evidence that she had those mental or nervous or psychiatric injuries. Here, Ms. Rodriguez neither claimed nor submitted any evidence of a mental or nervous or psychiatric injury. Her complaint alleged only that Ms. Davis, quote, exposed her to stress, close quote. McKinsey's dicta regarding the third sentence is of no weight. First, it's expressly hypothetical, including in stating that, quote, an example of this situation may be an employee gets stressed about something at work that causes them to suffer a heart attack, close quote. Second, it's unrelated to any of the facts of the McKinsey case or to any claim raised by any party. It's clearly dicta. Also, it talks about, quote, stress, although it earlier acknowledged a psychiatric injury is required. In addition, the hypothetical, since it's not based on any actual events, it's unclear. We don't know when this alleged heart attack might have occurred. Did it occur at work? Did it occur later? Was medical treatment required? We don't know. And again, I point out, the court said that the situation may be an employee gets stressed about something at work. The court didn't even say it would be. Also, it's important that in McKinsey, with respect to the third sentence, it uses the words trauma and injury interchangeably. It refers to a, quote, mental or nervous injury not accompanied by a physical injury requiring medical treatment that causes a subsequent physical injury. And it refers to mental or nervous trauma. However, Your Honors, this court doesn't have to decipher what is meant by McKinsey's discussion of the third sentence. The statute is clear. Evidence of a mental or nervous, i.e. a psychiatric injury is required, and there was none here. The only evidence in the record was that Ms. Rodriguez testified that she was stressed and she felt great pressure in her head and great pain in her back during the meeting. In fact, page 254 of the record shows that she agreed that she injured her back in the incident. So the only evidence that physical trauma or injuries for which she received medical treatment accompanied her stress. The burden was on Ms. Rodriguez to introduce sufficient evidence to create a genuine issue of fact to support the applicability of 440-0931, and she did not.
Ms.
Therefore,
Sacco, I want to switch gears to the intentional tort exception to the workers' compensation statute. And there, Ms. Rodriguez did have some affidavits that were filed. And I believe they were filed timely. I don't think there was any objection to when they were filed as far as the summary judgment rule goes. But the trial court expressly did not consider those affidavits. Does that play into the intentional tort exception? And should the trial court have considered those affidavits?
to answer your second question first, Your Honor, no, it shouldn't have considered them, and this court should not consider them. What is required under 440.11(1)(b)(1) is a deliberate intent to injure. And there's no evidence that Ms. Davis knew, as stated in the R.L. Haynes case, that it was, quote, virtually certain that Ms. Rodriguez would be physically injured. And as the court stated in Gorham, the legislature adopted an extremely strict exception, which we suspect few employees can meet. To date, we have not found, nor has a case been cited to us, where an employer has lost its immunity for its conduct, close quote.
Ms. Sacco, if I could stop you for a second, I think the first question that Judge Wozniak asked, or the thing you need to answer first, is should the judge have considered the affidavits? You're kind of arguing that the affidavits were insufficient to change the result, but should the judge have considered the affidavits?
So you're right, the judge should not, because those affidavits were obtained in opposition to the motion for summary judgment. I would point out that they were obtained 4 years after the incident, and they directly contradict Ms. Rodriguez's testimony, which was obtained 4 months after the incident.
Well, the fact
And
that they were obtained 4 years after, there may not have been a reason to obtain them beforehand. So I don't understand why that's a basis.
That's right.
And
The
the
actual
fact
reason,
that it contradicts the plaintiff's deposition testimony, you know, if the plaintiff was having these physical stress, fright, excitement, whatever, you know, there's certainly an argument that her recollection may not be as good as the other one. So I'm
Your
having
Honor,
trouble with that argument.
Your Honor, they directly contradict. The two affidavits say that Ms. Rodriguez asked 3 times to leave the office to get her blood pressure medicine, and 3 times Ms. Davis refused her and told her that if she did, she'd be fired. Ms. Rodriguez's testimony contradicts that in 2 ways. Ms. Rodriguez testified that as Ms. Davis was talking, she felt like her head was going to explode. Then Ms. Rodriguez started talking about how she'd been praised just the week before at work. And then suddenly she announced, "My head's going to explode." And she testified she got up and walked out.
Well, why don't those contradictions make an issue for trial?
Because they are directly contradictory. And under Lawson and other cases cited in my brief, when you have affidavits that are directly contradictory and are put forth just to avoid summary judgment, they should not be considered. And they are directly contradictory, Your Honor. And
Don't some of those cases deal with the plaintiff or one party on deposition saying one thing and then affidavit saying the opposite, something contradictory to avoid summary judgment? But here we have different witnesses.
Your Honor, that is the case for most of the cases, but the case I cited in the brief, I think the name is Kramer. It was 2 different situations. It was a witness to a car accident, was the first affidavit or testimony, and then the plaintiff herself testified the opposite. So it does not have to be the same witness. That case shows that clearly. And I direct the court's attention to the record at page 263 and 269, because the distinction here, Your Honor, is this extended, repeatedly asking to go leave the room to take blood pressure medicine, repeatedly being told not to, whereas Ms. Rodriguez's testimony very clearly says she announced her head was going to explode and she got up and left. In fact, the testimony goes on and says that, were you stopped? Did she run over to the door and stand in front of you? No. Did she close the door and say, "Damn it, you're not leaving"? No, no, no. You felt like you could leave and you did? You know, in all honesty, at that point, I really wasn't. I was just like, I have to leave. Whether it's appropriate or not, I couldn't. My health was at risk, clearly. So that's a very clear contradiction. Secondly, with respect to the blood pressure medication, Ms. Rodriguez also testified that she knew that it was bad, but she didn't know what it was. And that's clearly contradictory to saying, I need my blood pressure medicine. So there's two very clear contradictions. And because of that, because they were brought in to oppose the summary judgment motion at the last minute, those direct contradictory affidavits should not be considered. And even if they are considered, Your Honor, under the standards as set forth by the courts, such as in Gorman, 440.11.1b1 does not apply. The plaintiff didn't even allege deliberate intent to injure. She said she knew or should have known that this exposed Ms. Rodriguez to serious and unnecessary stress and anxiety. That's insufficient. And Ms. Rodriguez did not raise this in a reply. And this was not tried by consent. I would point out the case of Turf Express Inc. versus Palmer, 209 7 2nd 461, which held that Rule 1.190b regarding issues tried by consent, quote, by its express language is limited to the resolution of issues at a full trial. It does not apply to summary proceeding, close quote, meaning in that case, a summary judgment proceeding. In addition, even if the affidavits, Epic objected to the affidavits, and even if they were considered to be tried by consent, tried by consent doesn't apply here because the evidence admitted was relevant for another issue, the underlying claims of intentional infliction and the negligence claims. And I'd cite Book versus City of Winter Park, 718, 7 2nd 945 for that point. With respect to the intentional infliction claim, Your Honor, the underlying claim, I would point out that that Ms. Rodriguez simply, the facts, even alleged by the affidavits, do not hit the very high standard of outrageous required, particularly in an employment situation. And I'd cite the case of Hernandez versus Tallahassee Medical Center, a case cited by Ms. Rodriguez for a different point, where the employee had a seizure disorder and she'd been threatened to be fired if she didn't report to work on time. She spoke with her employer one morning and said, I feel like I have a seizure coming on. And he told her to report to work anyway, quote, right away. She drove, she had a seizure, she had an accident, and she was injured. The court held that requiring her to come to work, quote, right away, even under those circumstances, was not sufficiently outrageous to state a claim for intentional infliction. I'd also point out this court in Novotny said that there is no intentional infliction claim if the employer pursues his legal rights in a permissible way. This is so even if it will cause emotional distress. Quote, it's not enough that the intent is tortious or criminal. It's not enough that the defendant intended to inflict emotional distress. And it's not enough if the conduct was characterized by malice or aggravation, which would entitle the plaintiff to punitive damages for another tort, close quote. Simply the conduct here falls short to what constitutes outrageous conduct sufficient to state a claim for intentional infliction. We argued this at the trial level, that the conduct was not outrageous enough, and the court said that the facts, even when drawing every possible inference in favor of the plaintiff, did not state a claim for intentional infliction. And finally, Your Honor, with respect to the negligence claim, I'd like to focus on the proximate causation element. There is no evidence that proximate causation exists. Ms. Rodriguez did not address this argument in her initial brief, and therefore it was waived. However, it was argued below, and the trial court ruled on it. The Florida Supreme Court and Florida Power and Light says, and I quote, the proximate causation element is concerned with whether and to what extent the defendant's conduct foreseeably and substantially caused the specific injury that actually occurred. The trial court's order parallels this, stating, and I quote, there is no evidence that there was any foreseeability that the actions on the part of the employer caused the condition of which plaintiff now allegedly suffers. Close quote. That's page 482 of the record. So the court found there was no proximate cause. This court in the city of Ocala reversed the denial of a directed verdict, holding a reasonable person could not foresee plaintiff's, quote, specific injury. Here, there is no evidence, even under the affidavit's version of events, that it was foreseeable that delaying Ms. Rodriguez from getting her medicine would result in the specific injuries of a subdural hematoma and subarachnoid hemorrhage. Therefore, the element of proximate causation cannot be shown. In conclusion, Your Honors, at first glance, this case may appear to raise difficult issues of statutory construction, but resolution here is not difficult. The 440-093 exception only applies when there is evidence of a mental or nervous injury, and there was none here. The summary judgment, Your Honors, should be affirmed. Thank you.
Okay, for the appellant, any rebuttal?
Yes, Your Honor. And so to just begin at the top of the list and go down, I'm going to focus this rebuttal mostly on the intentional tort exception. Unless the court has questions about something else, I'll rely on my briefs.
I do have one other question.
Yes, Your
Opposing counsel argued, and I'm looking at the complaint, that the complaint did not allege the existence of a mental or nervous injury. So, is that relevant to the issue of who determines the burden when it wasn't alleged, if it wasn't alleged in the complaint?
No, Your Honor.
Alleged in the complaint, can you tell me where?
No, Your Honor, it wouldn't be, because it would be first raised in the affirmative defense. At the complaint stage, Ms. Rodriguez didn't have any burden to plead that.
Okay. All right, go ahead with the rest of your argument then.
Thank you, Your Honor. And so with regard to the intentional tort exception, Epic argues that the affidavits don't present any evidence to show that Ms. Davis could have known or knew that injury to Ms. Rodriguez was virtually certain. And Epic argues that Ms. Rodriguez's affidavits directly contradict, in their own words, her deposition testimony. And Your Honor, the record does not support either of these points. To begin with, the record, when interpreted in the light most favorable to Ms. Rodriguez, shows that a gap of between 20 and 30 minutes passed between the onset of her symptoms and the point at which she left the meeting. There is not a situation where she begins to feel discomfort or feel intense pain and then says, my head's going to explode, and immediately gets up and walks out. There's a 20-minute gap there at the very least, and that's only based on Ms. Rodriguez's deposition testimony, not the affidavits.
What evidence is there that Mrs. Davis was aware of plaintiff's medical condition?
Your Honor, if you mean her medical status as someone with hypertension and a cancer survivor, the record reflects that it was sort of generalized knowledge in the office. But as far as the specific medical condition, the medical emergency that Ms. Rodriguez was experiencing, it would have been the evidence of Ms. Davis's own eyes. Other people in the room, Ms. Teasdale and Mr. Armstrong, noticed it. And as soon as Ms. Davis exited the room and colleagues who hadn't been in the room saw her, their immediate reaction, the record reflects, is to scream, "Oh my God," and call 911. So
where is that? Is that in the affidavits only, or is that elsewhere in the record?
That's in Ms. Rodriguez's deposition, Your Honor. And
well, she knew what they were saying after she left the room?
No, Your Honor, that's after she exits the room. Her other colleagues who are outside the room see her, and she hears and sees them say, "Oh my God," and call 911.
Okay.
And so, but the affidavits are proper for this court to consider because they don't directly contradict Ms. Rodriguez's deposition testimony. They present additional evidence. And the Epic relies on Kramer, which is a 3rd District case from 1959, with which this court is free to disagree for the principle that other witnesses' affidavits can be sufficient to create a contradiction.
Mr. Howard, where in the initial brief does Ms. Rodriguez argue that the trial court erred in not considering the affidavits?
She does argue it in the initial brief, Your Honor. I don't have the page off the top of my head, but that would have been during section 1B after page 28, I believe, is where it should come in, that the affidavits were consistent, that the trial court had failed to consider this information. But Ms. Rodriguez does argue in her initial brief that the affidavits were proper, that they did not contradict her deposition testimony, and that the trial court should have considered those facts. So, Your Honor, when the trial court, with consideration of those facts, what the trial court should have held is that there was a gap of between, that the meeting lasted for as much as an hour, that the The evidence shows that Ms. Rodriguez began to experience discomfort about 15 minutes in, and then for as much as 20 or 30 minutes, Ms. Davis had the opportunity to observe her, that the injury was foreseeable, that Ms. Teasdale did in fact foresee it, and that this is sufficient also to satisfy the standard of proximate cause, which the trial court did not rule on. It ruled on whether foreseeability existed as a component of the existence of a duty, not proximate cause. But proximate cause is demonstrated in this case because Ms. Rodriguez's injury was a part of or Ms. Davis's actions were part of a natural and continuous sequence that resulted in Ms. Rodriguez's injury, which is the proximate cause standard.
Okay, well, thank you, Mr. Howard. Your time is up. Thank you both. And the court will be in recess.
Thank you, Your Honor.
Thank you, Your Honors.